Thank you. Please be seated. We're here for oral argument in case number 1 CV 16-0678, Shield Security and Patrol LLC versus LIONHEART Security and Consulting LLC. Council, I remind you that these oral argument is being recorded, so if you'll please identify yourselves and who you represent at the beginning of your arguments. Counsel for appellant, you'll have 20 minutes in which to argue your case. You're responsible to watch the clock and save as much time as you need for rebuttal. So each side will have 20 minutes. Also, please keep in mind we've read the briefs and we've conferenced the case earlier this morning. With that, counsel for appellant, you may proceed.
Thank you, Your Honor. My name is Mark Saveda. I represent the appellants Michael Morrison, Joshua Hosienik, Logan Coleman, Frank Sheldon, Adam Lay, and LIONHEART Security. I would like to reserve 5 minutes of rebuttal time. May it please the court, with this appeal, the appellants are requesting that the court reverse a decision of the trial court which denied the appellant's motion to compel arbitration. The key issue before this court is whether or not the Federal Arbitration Act preempts Arizona law that exempts arbitration agreements and employment contracts from Arizona's versions of the Uniform Arbitration Act and the revised Uniform Arbitration Act. And those particular statutes are codified at ARS 12-1517 and 12-3003B1.
Can I clarify on that very point? Because it seems to me we're really only talking about the Arizona Revised Uniform Arbitration Act 12-3003 because of when the employment agreement was signed. Isn't that true?
That is true, Your Honor, from a time frame. The way that this came about was in the complaint, the appellee specifically indicated that they believed that it was not subject to arbitration pursuant to 12-1517, and that's one of the reasons that it was raised in the trial court.
Both of you have cited that, but I just wanted to clarify. There's really no dispute that Mr. Morrison signed his agreement in 2014, so it's the Arizona Revised Uniform Arbitration Act that really applies, correct?
Yes, Your Honor.
Okay.
I agree. And the FAA basically states, and I just paraphrase, that any provision in a written contract that evidences a transaction involving commerce to settle a controversy by arbitration shall be valid, enforceable, and irrevocable except upon such grounds may exist at law and equity for the revocation of any contract. We have a conflict with and I'm just going to cite then to 12303B1, which basically says in the context of arbitration, Arizona is not going to allow arbitration that arises from an employment agreement. So the issue is whether or not the FAA preempts that particular statute. If we look at the Supreme Court decision in Circuit City Stores versus Adams, the court held that the FAA applies to arbitration agreements and contracts of employment. The Supreme Court in Arizona did tangentially in the North Valley case have the opportunity to consider that particular issue, but they declined in terms of to look at the preemption issue, finding that the preemption argument wasn't raised in the trial court or the Court of Appeals. I would like to note, bring to the court's attention, there was a recent decision that came down from the Arizona Supreme Court on July 21 of this year, Hamblin, Hamblen versus Hatch. It cites CV16-0260-PR, and I did inform the appellee's counsel that I was just going to mention this case to the court so you could take a look at it. The Hamlin court, that particular case involved, there were an employment agreement, there were parties to an employment agreement, employer-employee, but they specifically opted in to arbitration. So the preemption argument was not raised before the Arizona Supreme Court, but they did talk about two important aspects of preemption. They did indicate in that particular Supreme Court opinion the FAA preempts state law and governs all written arbitration agreements involving interstate commerce, making such agreements enforceable in state and federal court. And they also stated the FAA applies to arbitration agreements in employment contracts, citing the Circuit City Stores versus Adams.
Mr. Sveda, let me jump ahead a minute. Let's assume for the sake of argument that the FAA preempts Arizona law on this point. What arguments or evidence were before the Superior Court that demonstrated that this employment agreement substantially affects interstate commerce?
Okay, there are a number of issues, Your Honor. First of all,
and I want to limit it to the record before the court, because I think you make some arguments on appeal that weren't before the court, and we only review what the court had in front of it when it ruled.
in specifically what the appellants are relying on in this case, Your Honor, for evidence. First of all, is the employment agreement itself, which is attached as Exhibit 5 to the record on appeal, the complaint. And that specific document references the fact that the parties contemplated that Shield would need to get federal licenses, or as the manager, Mr. Morrison, would need to get federal licenses to the extent that there was going to be any federal licenses required for their going forward with their business. The other evidence is that there is a series of emails that are attached as Exhibit 4, it's a record on appeal 1, the complaint, that specifically discuss the fact that they had provided services at the Super Bowl on February 1 of 2015. There's another in Arizona. That's correct. That particular event happened in Arizona. There was some emails where there were the copies of the contracts were not exchanged, but there was emails where there were contracts being sent to Shield to provide security services for the Phoenix Open Golf Tournament and for the Barrett-Jackson auction. So with respect to that interstate commerce prong, it's important to look at it in terms of how far does the involving commerce aspect of the FAA go. And the Supreme Court decisions has basically said it's to the furthest extent allowed by the Commerce Clause. And what has happened for example, the Alafabco case, the court said, Citizens Bank versus Alafabco, they said that the proper inquiry, at least in terms of looking at this interstate commerce argument, is not upon the individual transaction itself, but rather upon the general consideration of the general practice those transactions represent. So you look at it and you see, okay, what is Shield doing in this particular case? They're providing services to the Super Bowl. They're potentially providing services to Barrett-Jackson and for the Phoenix Open Golf Tournament. Those aren't just national events. Those are international events. So providing security services to those particular events would implicate a general practice that affects interstate commerce.
But doesn't that sweep so broadly that anytime you have an event where someone comes from out of state or lettuce is shipped from Mexico, that opens the FAA to totally preempt every state law clause on this? I mean, it would, to me, read out the interstate commerce evidentiary requirement, because you can always envision interstate commerce, I think, in any transaction in day-to-day life.
Well, that would be my interpretation of the way that the U.S. Supreme Court is going with this, because if you look at the Alafabco case, they said, okay, this particular case involved commercial lending. And the court said that particular aspect of commerce, commercial lending, impacts interstate commerce. If we looked at the
Don't you think they loaned money outside the state or in that case? I haven't read the case, but don't you think there was some evidence that they were actually loaning money in different states?
I think in that particular case that the Alafabco was doing some business within the southeastern United States. It wasn't specifically that there was lending, but they had looked at the fact that there was other activity going on outside the state of Alabama in that particular case.
I mean, I also share the concern of the breadth that could be possible here. I mean, just putting in an example, I mean, if you have an employee whose job is to do ordering for the company and they order off of Amazon primarily, I mean, is that interstate commerce?
I think that it is.
They order pencils.
I think that it is.
One box. That's.
I think that it is. Does it impact? I think with the.
Then isn't it going to be just so broad? I mean, I can't think of an example where an employee, any employee, wouldn't have touched some interstate commerce.
The terminology that the Supreme Court has used is, what's the general practice? What's the general practice of the business? What are they doing? Whether it be commercial lending, in the Wilczewski case from Nebraska Supreme Court that found preemption, they found that even though it was a localized foreclosure within the state of Nebraska, the residential lending impacts interstate commerce. So I would submit to you that because we're providing security services that impact, that have a broad range in Arizona, security services could have been provided out of state, but when you have impact on this from the Super Bowl, from the Phoenix Open, from Barrett-Jackson, those particular types of contacts are the general practice that the U.S. Supreme Court is looking at and determining whether it involves interstate commerce.
Can you think of any commercial activity, given the definition that you're asking us to adopt, that would not trigger interstate commerce?
Perhaps we could have a circumstance where, let's say that there was an employment agreement with a nanny, a family and a nanny, and the nanny was only providing services in a home in Arizona, and that was the extent of that nanny's work.
But what if she emailed to the parents while they were in Florida?
I guess the way that I look at it is that particular fact pattern that I offered is a very localized type transaction. So the argument that this is intrastate in character, or the general practice, I'm not involved in a multi-state business. I'm just providing services for one family within the state of Arizona. If you compare it to a circumstance where you have provision of security services for multinational events, that's a whole different fact pattern. So I would believe that perhaps in that particular circumstance of the nanny for the individual home in Arizona, we wouldn't have preemption because there's no impact on interstate commerce.
It could be, but you know, in reading, and I learned something from this case, which is that the court is to apply the same standards as summary judgment when ruling on a motion to compel arbitration. So the question is whether the movement to compel arbitration has come forward with evidence creating a fact issue sufficient to hold an evidentiary hearing on the issue. And so I'm looking at what in the record, and I know you've cited allegations of the complaint and emails that are exhibits, but I didn't really see that robustly litigated in the Superior Court. In fact, I think opposing counsel made the argument when the motion was argued that this doesn't affect interstate commerce, and the response that I see is that, I believe as you said, security services could be provided to out-of-state entities and that SHIELD could purchase security supplies such as guns or uniforms from outside the state of Arizona. That's not the kind of competent evidence that you usually associate with getting past summary judgment.
No, I would agree with that, Your Honor, in terms of what was argued at the oral argument in Superior Court. But if you want to look at what was the record before the Superior Court, and you take the allegations of the verified complaint as true, which we would for purposes of this argument.
Wait, I thought Judge Downey just said we're treating this as a summary judgment.
That would be a Rule 12b-6 standard.
Right. Well, if you're going to consider the evidence that's in the record, and if you want to consider the emails that are attached to the complaint.
But doesn't the Superior Court have to be, I mean, the Superior Court's not an advocate, doesn't search the record and say, aha, that could defeat summary judgment. It responds to the arguments that are made. And so that's where I'm struggling. I get that that wasn't the focal point of the argument, but it clearly was raised by opposing counsel for SHIELD.
No, I understand that, Your Honor. I understand that certainly the record on appeal was sparse. We did not submit any declarations or any other evidence with respect to the impact on interstate commerce. And in fact, what happened in that particular case was that particular issue, the impact of interstate commerce was raised by the appellee at oral argument. So for that particular reason, that's my belief that that was not more substantially developed in the record below. Just to comment briefly with respect to assuming that preemption is found and that there's a link with interstate commerce, then the question becomes, what about the non-signatories to the employment agreement? And we had argued that it would be appropriate for the court to apply equitable estoppel to require the non-signatories to the contract to also participate in the arbitration.
Would that be an abuse of discretion standard? I mean, how would the judge decide whether the non-parties should come into that litigation?
Well,
to arbitration.
Well, I think that what we argued was it's equitable estoppel. There's a legal principle that supports that. So I don't know if it would be abuse of discretion or not. The particular test is what's the nature of the relationship between the parties, and then is there an interconnection between the allegations that are made and the parties' conduct. In this particular case, we have the non-signatories, and what the plaintiff alleged is that all these persons had some sort of employment relationship with SHIELD, that they owed certain duties to SHIELD, fiduciary duty, duty of nondisclosure, duty not to compete, that all those duties were breached. And in fact, what the appellants allegedly did was conspired together, engaged in concerted conduct to basically take business away from Shield. So we would submit that under the test of the Toyota case that we cited, that it would be appropriate to apply equitable estoppel in this case to require all of the non-signatories to the employment agreement to participate in arbitration. And if the court doesn't have any further questions, I'll reserve the rest of my time.
Okay. No questions. Thank you. Counsel?
Good morning, may it please the court. Joshua Wheelock on behalf of the appellee / plaintiff in this case, Shield Security and Patrol. Your Honors, just to touch briefly on a few points before getting into a more in-depth Commerce Clause analysis. Really, we're here today reviewing whether or not the lower court erred in denying the appellant's motion to compel arbitration. Whether or not there's issues of preemption as it relates to the Federal Arbitration Act, it doesn't really matter because in this case, Arizona law controls and it is applied via the choice of law clause within this agreement. Case law supports that a choice of law clause will still control, and that law, even though it may be preempted by federal law, would still apply, which would be this case here as it relates to this particular issue. Additionally, there are a series of issues raised in this appeal that were not raised at the trial court level, such as the common law principles, and that was addressed directly on the opinion written by the lower court, as well as the equitable estoppel issue. Opposing counsel did mention issues as it relates to the Commerce Clause issue being first raised at oral argument. That is incorrect. Issues as it relates to the Commerce Clause and preemption were in fact raised in the plaintiff's response to the defendant's motion to compel arbitration, and that should be a part of the register of actions, Your Honors. Again, I think the focal point here is it's looking at what the lower court did and how that intertwines with appellant's, I guess, appeal here, Your Honors. The Court of Appeals reviews the record and evidence in the light most favorable to sustaining the trial court's ruling, which in this case would be to deny arbitration under Arizona law. It is clear under Arizona law that arbitration does not apply to agreements as it relates to employer and employee. There was some mention as it relates to issues arising out of the Commerce Clause that opposing counsel had referenced, and cites evidence attached in plaintiff's complaint. Oddly enough, those emails and those documents that they're relying upon to create an issue of interstate commerce were documents and actions that the appellants were actually conducting on behalf of defendant Lionheart to further Lionheart's business, which actually gives rise to this case. When you focus in on the employee-employer agreement between Shield and Morrison, it's 4 acts that Morrison will do for Shield. It's not a consideration that Morrison's going to be doing actions outside of the state of Arizona. This was for security services to be provided within the state of Arizona, licensed under the state of Arizona. Nothing leaves the state of Arizona, both residents, etc.
Maybe you have. It just seems like opposing counsel's view of this is that it's quite broad. That if you touch interstate commerce, then it's going to fall under the FAA. What's your counter to that argument? I mean, you know, a security company, and I don't know the ins and outs of security companies, but it seems like they're going to be like many companies who now in this day and age, it's pretty tough to say that you're limited to one state through email, phone, ordering, Amazon. I mean, everything that touches a business in this day and age. How can you say that it doesn't involve interstate commerce under the definition that's opposing counsel's advocated?
Under opposing counsel's view, essentially everything would fall under this realm. Nothing would be outside of this realm. It would be so broad that essentially the Arizona statute related to this specific arbitration issue would be null and void, because it would, Federal Arbitration Act would preempt essentially every agreement, because everything would touch it. I think if we look back at opposing counsel's example as it relates to the nanny, where opposing counsel had tried to narrow it down to where this is a particular instance where it doesn't affect interstate commerce at all. The services that the nanny is providing arguably are no different from what a security guard company is doing. It is within the state, providing services within the state for people that are here within the state. If there are issues as it relates to how that interaction is going to be, as it relates to potentially pencils being purchased or sold on Amazon or eBay or whatever it may be, then we get into a question that everything falls under the realm of preemption here.
That's too broad. The focus, I don't think, is what does the company do. The focus is whether this particular employment contract substantially involves interstate commerce. And I thought you were starting to delve into what this particular employment contract's terms were. Because, yes, any company, I think, is going to impact interstate commerce. But the focus, as I read all of the authorities, is whether this employment contract involved interstate commerce, not whether the company did.
Absolutely, Your Honor. And in this case, the employment agreement itself was an agreement for employment within the state of Arizona. Nothing was listed there as far as providing security services outside of the state of Arizona. It was all within the state of Arizona, signed within the state. Everything that happened was within the state. And in fact, the license for security services is a state-issued license. Notwithstanding, again, there's a very clear choice of law clause.
Yeah, but, I mean, if you really want to get into that, what about this Mastro Bueno case from the U.S. Supreme Court, which seems to say unless the parties specifically say in their choice of law provision the FAA does not apply, that a general choice of law provision isn't going to matter?
Really, when
that's the U.S. Supreme Court.
Absolutely, Your Honor. And when you get into the details of that case, it's more of a conflict of law analysis as opposed to a choice of law. The real major issue within that case was whether or not punitive damages would be awarded via an arbitrator or via a judge from the court level. The challenge was there was a conflict between New York law and the arbitration clause in that case, where New York law specifically stated that an arbitrator cannot award punitive damages. And the court had to go through standard contract interpretation methods to really determine the intent of the parties. And when it applied the arbitration clause, there's a very narrowing language that a separate arbitration body would handle the arbitration in the event that it happened, and those rules would apply. And that's essentially how the court came up with punitive damages would be fine, because they're allowed under the additional realm of this arbitration body.
But wasn't there some pretty broad language that would lead a lowly state court like us to assume that when it says that you need a specific opt-out of the FAA clause and that a general forum selection clause wouldn't be enough? That I'm not sure that's your best argument.
Well, I think as it relates to the choice of law, it states that this agreement and everything essentially within the agreement is bound by Arizona law. And then if we were to further look at the arbitration clause that the plaintiff appellees alleging is not valid under Arizona law, specifically defines that it would fall under the realm of the jurisdiction of the Maricopa County courts, which would have then further evidence that Arizona law should control. As it relates to the equitable estoppel argument, again, not raised at the trial court, but if we were to review those issues, and any issue as it relates to equitable and estoppel, the courts will look at essentially a fairness standard. And in this case, the parties that are attempting to invoke equitable estoppel for arbitration, they're the tortfeasors. They're the ones that caused this. It's not a fairness thing that it's a judicial economy issue or anything along those lines. It's a fairness to the process, what had happened, what had transpired. Here we have tortfeasors that committed all sorts of acts against the plaintiff appellee in this case, and now they want to fall under the protection of an arbitration clause that they never signed. The issues are not intertwined. They do not raise to the level that they need to be litigated under the same guise of the employment contract with Morrison. It's a 7-count complaint alleging things ranging from tortious interference of a business contract to unjust enrichment, again, with individuals not signers of this agreement. So again, Your Honors, as it relates to the 3 issues really presented, whether or not this agreement is preempted or Arizona statute is preempted by federal law should not apply because of the very clear choice of law clause, that the issue of the common law breach of contract or contract term should not apply because it was not raised at the lower court. Also, the issue of equitable estoppel is not proper within this court because it was not raised properly in the lower court or ruled upon. And as it relates to the issues of interstate commerce, I would submit to the court that given the nature of this employment agreement, the interaction of the employer and employee, it does not raise to the levels that opposing counsel wishes as it relates to affecting interstate commerce, which would again take it outside of the realm of preemption.
Okay.
Thank you.
Counsel, thank you for your argument.
First, I'd just like to address the choice of law clause argument. That was just a basic choice of law clause saying that Arizona law would apply. And that simply is not enough based on the Mastrobono case to suggest that somehow that simple choice of law clause is going to overrule the FAA. One of the cases that was cited by the appellee was this Security Insurance Company versus Trustmark, which was a Second Circuit case. And this was important language out of that case. It says, quote, following Mastrobono, our circuit has held that a general choice of law provision will not be construed to impose substantive restrictions on the parties' rights under the Federal Arbitration Act. Essentially what they're trying to argue by utilizing that choice of law clause is that there is a substantive restriction that arises from that choice of law clause. It does not. Typically when courts will apply that choice of law case under the FAA is solely for procedural issues, determining what procedures are going to be utilized under state law in order to arbitrate that particular case. So that the choice of law clause is not a basis to argue that the FAA does not apply. They also argue that we had brought up the fact that at least the contract between Mr. Morrison and Shield, the terminology, it's enforceable as a common law contract term. We've argued that this is a contract. It's the employee, not the employer, that's seeking to enforce the arbitration clause. It's not there's bargain for consideration for that particular term, and there is nothing unfair that would require that, at least under contract law, that should allow Shield to be able to get out of that particular contract. Counsel also makes the argument that, well, there's all these issues were not raised in the trial court, and we did point out specifically that this court has the discretion to, even if waiver applies, the Court of Appeals has discretion to consider matters not raised in the trial court, and there are 2 particular important ones in this case. When the appellate court is considering a statute, and we're specifically considering 3003B1 in this particular case, and secondly, where the matter involved is one which affects the general public interest and is a matter of statewide importance. And I think this is that particular case because we have, it's basically unclear in Arizona if preemption is going to apply, how those particular statutes are going to relate to employment agreements. We have a lot of employment agreements that are being signed between companies and their employees. And I think it's an important matter within the state of Arizona that an appellate court in Arizona make a decision in terms of is the FAA going to preempt Arizona statute or not. So regardless of if the court was to somehow find that these issues were not raised in the trial court, this particular court can certainly address those issues for those reasons. And finally, I just want to return to the interstate commerce argument, because as I see the test is what's the general practice those transactions represent. So what's the general practice, the transactions that were ongoing between Mr. Morrison and his employer Shield? Certainly he was carrying out employment-related transactions. Certainly he was providing services at the Super Bowl. What's the general practice that he was doing? He was certainly engaged in transactions that affect interstate commerce and on a wide scale. So I would submit that if the court would review the particular language again and look at the facts of this case, the only conclusion that can be reached is that the interstate commerce did occur and consequently preemption would apply. And as a result, I would respectfully request that the court reverse the decision of the trial court and order the parties to go to arbitration. Thank you.
Thank you, counsel, both of you, for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. We'll take a couple minutes to recess and prepare the courtroom for the next argument.